Imagine waking up one morning in the heartland of the United States, a place where the promise of freedom and equal opportunity has long been woven into the very fabric of national identity. You check the headlines and see, to your shock, that something almost unthinkable could become reality. The status of American citizenship, an identity millions have always assumed was permanent and secure, now hangs by a thread. It can vanish, not through war or catastrophe, but with a few strokes of a pen and the shifting tides of politics. This is not a dystopian novel or a scene from a political thriller. This is the dramatic, high-stakes situation currently unfolding in American courtrooms and corridors of power. The outcome of this battle could redefine what it means to be American, and its ripple effects will be felt far beyond the borders of the United States. To truly grasp how the country arrived at this pivotal moment, we need to take a step back and revisit the origins of birthright citizenship, a concept that has shaped the American story for more than 1.5 centuries. After the devastation of the Civil War, the United States ratified the 14th Amendment to the Constitution in the year 1868. This historic amendment did something remarkable. It guaranteed that anyone born on American soil, regardless of the status of their parents, would be recognized as a citizen, entitled to all the rights and protections that come with that status. This principle, known as jus soli, Latin for right of the soil, was revolutionary at the time. It was a direct response to the injustices of slavery and racial exclusion, a commitment that the United States would never again allow a child to be born stateless or without rights, simply because of their ancestry. For generations, this promise helped transform America into a beacon for immigrants from all corners of the globe. Families arrived seeking opportunity, knowing their children would be welcomed as full participants in the American dream. But as the 21st century unfolded, the landscape shifted. Political debates grew more divisive, and birthright citizenship, once a bedrock of equality, became a lightning rod for controversy. Over the past decade, the topic has polarized lawmakers and voters alike. Supporters of the principle hail it as essential to American values, an anchor of fairness, justice, and inclusivity. Critics, however, label it a loophole that attracts undocumented immigrants and so-called birth tourists, undermining national sovereignty and the rule of law. The latest chapter in this ongoing debate exploded into public view in January of the year 2025. On the very day he took office for his new term, President Donald Trump signed an executive order with sweeping implications. The order sought to revoke automatic citizenship for children born in the United States to parents who are either undocumented immigrants or foreign visitors with temporary visas. This was not merely a symbolic gesture. It was a direct challenge to a constitutional guarantee that had stood for more than 150 years. The backlash was immediate and fierce. Civil rights organizations, immigrant advocacy groups, and legal scholars launched a barrage of legal challenges across the nation. Class action lawsuits emerged as a powerful tool, allowing affected families to band together and contest the order in federal courts. Judges across the country issued temporary injunctions, pausing the implementation of the policy while they considered its constitutionality. But the legal battle was just beginning. In June of 2025, the drama escalated to the highest court in the land. The United States Supreme Court, by a 6-3 majority, issued a decision that sent shockwaves through the legal community. The majority, led by Justice Amy Coney Barrett, ruled that lower federal courts should not have the power to block executive orders on a nationwide scale. Barrett wrote that federal courts must not become overseers of presidential action, a statement that sharply redefined the role of the judiciary in checking executive power. Justice Brett Kavanaugh, concurring, reinforced this perspective. He argued that while lower courts could address specific grievances, only the Supreme Court should have the authority to issue broad, nationwide rulings on federal statutes and executive actions. This was a clear message. The highest court would stand as the final arbiter in these constitutional showdowns, and the scope of judicial oversight was being narrowed. Yet not all justices agreed. Justice Sonia Sotomayor delivered a passionate dissent, describing the decision as a travesty for the rule of law. She warned that limiting the judiciary's ability to restrain the executive branch could open the door to unchecked presidential power. The American Civil Liberties Union, representing dozens of affected families, echoed these concerns and vowed to continue their fight in the courts. In a remarkable turn of events, a federal judge in New Hampshire, Joseph LaPlante, certified a class action lawsuit on behalf of every child born after February 20th, 2025, whose right to citizenship would be threatened by the executive order. Judge LaPlante's decision temporarily blocked the implementation of President Trump's policy once again and gave the federal government just 7 days to appeal the ruling. For thousands of newborns and their families, this was a desperately needed reprieve. But the battle was far from over. The White House, meanwhile, remained defiant. Spokesman Harrison Fields lashed out at the judge's ruling, calling it an obvious and unlawful attempt to circumvent the Supreme Court. He accused the court of abusing class action certification procedures and insisted that the administration would fight vigorously against what he described as rogue district judges interfering with the president's mandate. Legal scholars, such as Samuel Bray from Notre Dame Law School, have warned that these rapidly unfolding courtroom clashes are resetting the balance between the executive branch and the judiciary in profound ways. The power struggle is not just about legal technicalities. It is about the very structure of American governance. Emotions are running higher than ever, as the futures of potentially hundreds of thousands of children hang in the balance. At this historic crossroads, the core question emerges. Can the courts and the Constitution withstand the pressure of an aggressive executive order? Or is the United States on the verge of witnessing the most significant redefinition of its citizenship laws in over a century? To fully appreciate the stakes, let's explore why birthright citizenship has been so vital to American society. For many families, especially immigrants, the principle is more than just a legal technicality. It is a lifeline. It has offered a sense of security, belonging, and hope. For countless children, including the children of refugees and asylum seekers fleeing persecution, birthright citizenship has meant the difference between a life of opportunity and a life of uncertainty. Consider this. Each year, hundreds of thousands of children are born in the United States to parents who are not citizens. According to the Pew Research Center, in the year 2019, approximately 375,000 babies, nearly 1 in every 12 births, were born to undocumented immigrant parents. For these children, the promise of birthright citizenship has shielded them from the risk of statelessness, giving them the legal and social foundation to build successful lives. If the Trump administration's order is allowed to stand, the implications would be staggering. The first and most immediate consequence is the possibility that hundreds of thousands of children born on American soil could suddenly find themselves stateless. Statelessness is a devastating condition. Without citizenship in any country, people are often denied access to education, healthcare, employment, and even the ability to travel. International human rights organizations have long warned about the dangers of creating large populations of stateless individuals, noting that it can contribute to cycles of poverty, marginalization, and instability. Furthermore, if the legal battles continue without clear resolution, the country could see a patchwork of different citizenship standards emerge across states. Some states might interpret the law one way, granting citizenship to all children born within their borders, while others might adopt restrictive policies, leaving families in legal limbo. Such inconsistency would undermine the very idea of equal protection under the law, a cornerstone of the 14th Amendment. The consequences would not stop at the borders of the United States. History teaches us that when America changes its approach to citizenship and immigration, other countries take notice. In the late 19th and early 20th centuries, during massive waves of immigration, the United States' embrace of birthright citizenship inspired similar moves in countries like Canada and Mexico. Conversely, when America has restricted citizenship rights, as with the Chinese Exclusion Act of 1882 or the quota laws of the 1920s, those actions have sometimes emboldened other nations to adopt their own exclusionary policies. Let's take a closer look at the global picture. Over the past few decades, several countries have moved to restrict or abolish birthright citizenship, often in response to political pressure or demographic changes. For example, Australia ended unrestricted birthright citizenship in the year 1986, and Ireland followed suit in 2004. In both cases, the changes sparked intense debate and led to legal and social challenges for immigrant communities. If the United States were to follow a similar path, it could set a global precedent with unpredictable consequences. Back in Washington, the legal and political maneuvering continues at a fever pitch. The Trump administration, unsatisfied with judicial setbacks, is preparing to appeal Judge LaPlante's ruling, once again putting the question of birthright citizenship squarely in the national spotlight. Legal experts warn that the next move could bring the issue back before the Supreme Court, where the stakes are higher than ever. What happens if the Supreme Court upholds the executive order? The most likely scenario is the immediate exclusion of children born to undocumented immigrants and certain foreign visitors from American citizenship. This would not only affect newborns but could open the door to retroactive challenges for children born during the period of legal uncertainty. Advocacy groups like the ACLU are preparing for a protracted fight, both in the courts and in public opinion. Alternatively, the courts could reaffirm the constitutional guarantees of the 14th Amendment, striking down the executive order and sending a powerful message about the resilience of American institutions. Yet, even this would not end the debate. Opponents of birthright citizenship could shift their efforts to Congress, seeking to rewrite the amendment or its interpretation through new legislation. This could trigger a constitutional crisis, as any attempt to change such a fundamental principle would face vigorous opposition and likely years of legal wrangling. The American Civil Liberties Union's attorney, Cody Woofsey, has described the recent class action ruling as a victory for families and for the basic promise of America. This decision, Woofsey stated, protects the rights of children to be recognized as citizens, regardless of the circumstances of their birth. But as Justice Sotomayor's dissent in the Supreme Court warned, some fear that the executive branch is actively testing the limits of constitutional protections, daring the courts and the public to push back. The implications are not only legal and political, but deeply personal. For immigrant families, the uncertainty surrounding birthright citizenship creates anxiety and fear for their children's futures. Community organizations across the country are advising families to document their children's births carefully, to seek legal counsel, and to stay informed about changes in federal and state policies. In some states, local governments are exploring ways to provide alternative forms of identification or support for children at risk of losing their citizenship status. There is also a broader lesson here for anyone watching global trends in citizenship and migration. The United States is often seen as a bellwether, a country whose legal and political decisions set examples for others to follow. The principle of birthright citizenship, while controversial in some quarters, has historically been a model for inclusive nation building. If America moves away from this tradition, it could embolden other countries to adopt more restrictive policies, closing doors for millions of families worldwide. Let's imagine for a moment the practical realities. If birthright citizenship is redefined, hospitals, schools, and government agencies would need to change the way they verify and process citizenship status for newborns. The administrative burden would be immense, and the risk of errors and discrimination would rise. Families could face years of uncertainty, navigating complex legal processes to prove their children's right to remain in the only home they have ever known. At the same time, there is hope that the current crisis will spark renewed engagement and debate over the meaning of citizenship. Across the country, universities are hosting forums, legal clinics are providing free advice to families, and advocacy groups are mobilizing supporters to contact their elected representatives. Social media campaigns are raising awareness about the importance of birthright citizenship, urging Americans to defend a principle that has been at the heart of the nation's identity for generations. For individuals concerned about their own families or communities, there are steps you can take. Stay informed by following reputable news sources and legal updates. Reach out to local immigrant rights organizations for support and legal advice. Participate in community meetings or online forums to share information and advocate for policies that protect the rights of all children. And most importantly, engage in the political process. Contact your representatives, vote in local and national elections, and make your voice heard on issues that matter to you. The current debate over birthright citizenship is not occurring in a vacuum. It is part of a broader global conversation about who belongs, who has rights, and how nations define their communities in a rapidly changing world. As economic, technological, and demographic shifts continue to reshape societies, questions of citizenship and identity will only become more pressing. Historically, moments of crisis have often led to new understandings and reforms. The United States has faced challenges to citizenship before. For example, in the early 20th century, Congress debated whether to restrict birthright citizenship during periods of high immigration, particularly from Southern and Eastern Europe. Ultimately, the country chose to maintain the principle, recognizing its importance for national unity and social cohesion. Today, the echoes of those debates can be heard in the halls of Congress and the chambers of the Supreme Court. Remember, what happens in the United States often sets a precedent for other countries grappling with similar questions about immigration and citizenship. As American courts and politicians wrestle with these fundamental ideas, your knowledge of these developments gives you an invaluable edge. Whether you are a student, a policymaker, an entrepreneur, or simply a curious citizen committed to justice and fairness. Here's a secret fact that even many legal scholars overlook. The debates about citizenship that are raging today are directly descended from those of more than a century ago, when America was grappling with waves of newcomers and the challenges of forging a unified nation. The lesson then, as now, is that the struggle over citizenship is ultimately a struggle over identity, belonging, and the meaning of the American promise. If you found this breakdown insightful, don't forget to hit like, subscribe, and share your thoughts below. What do you think the future holds for birthright citizenship and for the American identity itself?